Good evening, everyone. Welcome, everyone joining us in this event, as well as everyone who's following us through the different channels and social media. Please welcome. And well, today I feel honored being able to moderate this roundtable with three talented women, distinguished women that undoubtedly are a referent when it comes to gender matters on a national and international level. I want to appreciate the invitation made by Ana Maria Ibarra, the director of the Constitutional Study Center of the Supreme Court of Justice, to become the moderator of this event. So we are really happy by being able to share this topic with all of you. This is the first of a series of international conferences organized by the Center of Constitutional Studies of the Supreme Court of Justice of the Nation in alliance with the International Network of Constitutional Family Law. The goal of this conference cycle is to debate all the different topics related to family rights, to the fundamental rights, and the interpretation, the jurisprudential interpretation of these rights on a national and international level. This cycle of conferences is taking place in the framework of a general line of work published by this center starting back in 2019, through which it has allowed the center to develop a full doctrine, dogmatic and jurisprudential doctrine with a focus on compared law. In this context, the center has published several works. I want to share with you a few of them. The Constitutionalization of Family Law, Compared Perspectives, which was published in 2019. Parental Responsibility in Law, a Compared Perspective in 2021, and two works that will be published this year. Gestation by Subrogation in Latin America, the Constitutionalization of the Rights of Children in Latin America. And this first session of this cycle has the goal to put more focus on this challenge of gender violence in family law, as well as the response that we are giving to it, as well as how we should approach it from the different judicial systems. Before we welcome our speakers and I introduce them, I'd like to share with you a number that I was preparing my words for this cycle, and it was really scandalous. Actually, it's shocking to see that, well, by itself, this number can summarize the importance and the size of this issue that we are all facing. According to the Population Fund of the UN, by publishing the Gender Violence Report in 2020, they reported that it is estimated that 1 out of 3 women have suffered or will suffer from sexual abuse or physical abuse throughout their lives. 1 out of every 3 women. I think this is a number that we cannot overlook. I mean, this forces us to act immediately in the different scopes and the different competences. I don't want to take more of your time. The members of this table will give us more information about this topic, and I will now proceed to introduce them. First, we have the pleasure and honor of presenting the Minister Esquivel Mossa. She doesn't need an introduction. However, I want to highlight some information that is important to mention. She's the current Minister of the Supreme Court of Justice of the Nation. She is the President of the Second Court in the period of 2020 to 2022. She is a licentiate in law from the National Autonomous University of Mexico, also a PhD. She has a PhD in law from the Complutense University of Madrid and the Universidad Anáhuac. She has been in the legal and government subdelegation. She is specialized in administrative and fiscal law and in the Mexican financial sector. And she also studied in the Pan American University. She has more than 35 years as a public official, participating in the 3 levels of government. In these past 21 years, she has been working in the jurisdictional scope. In 2021, she was appointed president of the Second Court of the Supreme Court of Justice for the period of 2021 to 2022, and appointed by the Minister of the High Court and the representative of this body in the Interinstitutional Committee of Gender Equality of the judicial power of the Federation. She has been promoting and defending human rights, emphasizing on vulnerable groups like women, children, adolescent, disabilities, and the elderly. I'm going to give the floor to the minister. Welcome. Thank you. Good afternoon, everyone. I want to salute Alejandra Spitalier, General Secretary of the Presidency of the Supreme Court of Justice of the Nation, as well as Dr. Ana Maria Ibarra Holguín, Director of the Center of Constitutional Studies of the Supreme Court of Justice of the Nation. Today, they are calling us on this interesting cycle of international conferences on constitutional family law, where we will discuss relevant topics. Mrs. Spitalier has mentioned some of these topics, and we will cover them later on. I want to celebrate being able to share this first session with Professor Shazia Choudhry, an academician from Oxford University. It's a pleasure to salute you, as well as Reem Alsalem, the United Nations Special Rapporteur on Violence Against Women. Dear judges, public officials of the judicial power, and all the auditorium watching us. For me, it is a privilege to make this joint reflection from different perspectives on the specific challenges of the justice systems, the role of judges and the other stakeholders of the justice system on this problematic that unfortunately is common to all societies. Gender violence in a especially sensitive scope such as family, in which center specialists agree. This process is emerging by reproducing cultural patterns that dictate the dominance of men over women. But what is the current situation of violence against women and family violence in Mexico? Fighting violence against women is of great concern. As a woman, as a minister of the Supreme Court of Justice, it is overwhelming to listen to the daily news, the new cases of brutal aggressions against them, the statistics that are growing. For all of these facts, the number of emergency calls requesting for help in order to save their lives or their children's lives. In summary, this exacerbated violence is unbearable. I want to share some information so you have a clear idea what I'm saying. According to the numbers of the Executive Secretariat of the National Public Security System in 2021, it is a year when they presented the highest numbers ever to be recorded in this entity. We have 109 feminicides back in August, 272 intentional homicides of women also in August. 2017 alleged offenses of rape in March, 23,908 alleged crimes of family violence in May. And when it comes to 911 calls, it was recorded more than 690,298 emergency calls on a national level due to violence against women. I mean, almost 2 calls per minute. But what is the response of the state to this attack, to these lives that are in danger, these lives asking for help? In relation to the family violence crime, it says that in 2021, 253,736 alleged crimes were registered on a national level. In this sense, the National Institute of Statistics and Geography, INEGI, reveals that the crimes recorded in the criminal proceedings centered on a local level during 2019. Family violence occupies the third place with a 12.5%, preceded only by the crime of robbery and crimes against health. In 2020, they maintained that position, but with a slight descent. In 2022, in January, this executive secretariat of the national system that I was mentioning before is reporting a total of 292 violent deaths by women, 217 intentional homicides, and 75 feminicides, as well as 17,389 alleged crimes of family violence. This last number considered both for victims, male and female. This is from January 2022. When it comes to this black number, INEGI also states that from the National Survey of the Victimization and Perception of Public Security, MBIPE, of 2021, they estimate that in the year 2020, only 10.1% of these crimes were reported, for which the prosecution authorities started an investigation file of only 66.9% of those cases, which implies that 93.3% of these crimes there was no claim made, no report or no investigation file started. Nowadays, although we have some information from the reports of the Executive Secretariat of the National System of Public Security and the surveys conducted by INEGI, we don't have enough information on these investigation files that are processed and that lead to a guilty verdict. But the legal framework in Mexico says that we have a good archive of provisions that guard the equality of women and addresses gender violence, from the Constitution that acknowledges the principles of equality and non-discrimination, both as the protection of family, the organization and development, the international treaties in terms of human rights subscribed by Mexico, and a good number of laws, as well as a constant concern to strengthen the legal framework. Among the most recent reforms, we can highlight the constitutional reform in terms of gender equality from 2019 in order to prevent the violence, the political violence of gender, also the reform on the General Act of Women to have access to a violence-free life, and the Federal Criminal Code to include the concepts of digital and mediatic violence against women in 2021, as well as the reform to the General Act in terms of protection orders for women from 2021 as well. It is internationally known that we need to make reference to the Articles 7 and 8 of the Inter-American Convention to Prevent, Sanction, and Eradicate Violence Against Women, Belém do Pará, from 1995, which refers to the obligations of the state in case of violence against women that include the procedures, the mechanisms, all the legislation, as well as the different measures to protect the acts of imminent violence, among other things, in order to ensure human rights of women, so they can be protected, to respect them, to promote them, and to execute these human rights, as well as to guarantee the investigation and the collection of statistics and more information pertaining to the causes, consequences, the frequency of violence against women, a full mapping of what is happening in each state that are members of the Belém do Pará Convention, with the purpose of assessing the effectiveness of the measures to prevent, sanction, and eliminate violence against women, and to formulate and introduce the necessary changes. To this regulation, we need to add that coming from the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, and the Convention of the Rights of the Child. On the secondary legislation, I want to quote the General Act on Access of Women for a Violence-Free Life from 2007 that acknowledges the different types of violence against women, as well as the different scopes in which these are produced, with special attention to the family scope, prescribing a set of measures and actions to protect victims as part of the obligations of the state to guarantee women and their safety and their full exercise of their rights. On this law, I would like to stop in a figure that was incorporated, the protection orders, those that constitute a mechanism for prevention that provides a protection framework for these acts that will endanger their integrity, their freedom, and the life of women and girls, and that was reinforced cleverly and reformed in 2021, but unfortunately not all the different entities have implemented it. On those with jurisdictional nature, in the framework of the National Pact on Gender Justice that recently all the bodies subscribed for the administration of justice in Mexico, it was collected we collected information from 27 high courts of the different entities of this country, and in a first approach, out of these 20 bodies that do have records of protection orders, we obtain a total of 661,404 measures granted between 2019 and 2021, and 3,299 measures were denied. It is evident that the protection orders have had a positive effect on the life of 61,404 women that lived or are living violence. They are living this operation, they are observing this operation and this effectiveness, and that is the goal of all of this. On the other hand, the civil codes in which all the regulations are settled are dragging old conceptions that until a few decades ago had remained untouched. It was recently when they started to incorporate some changes when it comes to the social transformations that are impacting the organization, the structure, and the conception of families, and that are now recognizing phenomena like violence in their interior or also child abuse. The same thing happens in criminal matters. The Federal Criminal Code, as well as the different codes of the entities of Mexico, are typifying the family violence crime. For example, the Criminal Code of Mexico City, although they are typifying this crime, are subjecting the aggressor to specialized treatment according to what the Act of Women Access to a Violence-Free Life is foreseeing. Now let's talk about jurisprudential development. What has happened in the Supreme Court of Justice and in the judicial power? There has been a great promotion of the human rights of women, girls, boys, adolescents from the doctrine of the Supreme Court of Justice that started to have more strength from the internationalization of the human rights with the reform that happened in 2011 and recognizing the horizontal effectiveness as well as the social transformations that we are living. The Supreme Court of Justice, through the resolutions, has granted the framework in order to interpret and to understand family, its protection, all the different relationships, marriage, adoption, divorce, guardianship, custody, the interests of the minor, the rights of minors to have a name, an identity, of being born, to be free of violence, discrimination, inequality, double shift work for women, compensations, pensions, economic, patrimonial violence, application of justice with gender perspective, among other things. And we want to highlight the approach of family violence, acknowledging the acts of violence in this environment that affect those that are in disadvantage due to sex, gender, disability, age, that are seeing other ways of oppression that are manifested in the household. We can highlight that it has been recognized that the right of living in a good family environment free of violence is part of the catalog of human rights that has been appointed by the court, and we need to consider that integrated as part of the national order by being recognized in different international treaties that we have already mentioned, as well as everything coming from the rights of life, health, integrity, dignity of people, equality, and the establishment of conditions for personal development, where we are still following as consequence that all of these acts that become family violence constitute a wrongful act, and the penalization and everything is trespassing the public order rules established on an international constitutional level. Out of the nature of this law, we have observed also different ways of judging and presenting evidence. According to the Supreme Court of Justice, we need more evidence in order to clarify the violation to the physical integrity of that person that has been abused. Because a person that says to be a victim of family violence is under a disadvantage. In this order, they have sustained that the judge should need to focus on even the smallest evidence that puts this person in danger in order to dictate and prevent without being able to verify the harm. The same thing has established special rules for valuing the testimony of victims of sexual violence. And in another affair, when it comes to the obligation to repair, the response from the judicial power when it comes to violence and discrimination against women should not only emphasize a violation by an authority, but it should also look to change a conduct in society. This is with a transformative perspective that will measure their restorative effects as well as the corrective effects with the purpose of complying with the respect and guarantee as well as to repair the violations of human rights acknowledged in the first article of the Constitution, emphasizing, furthermore, the characteristics that should be part of the repair measures when there's a violation of human rights of women. Also, trying to repair, in these cases of family business, it is considered a wrongful act that it can create patrimonial and extra-patrimonial affectation, and it has been established that once the elements have been configured for civil responsibility due to family violence, need an economic repair, both the patrimonial and the moral damage. When it comes to the repair, we should set a precedent of relevance. I am talking about the direct amparo remedy in review 5490/2016 under the administration of Minister Arturo Saldívar, where it was made evident that there is a structural discrimination within the violence that is executed against women in the household. Some data of these cases tell us that everything started in a case when a marriage was dissolved in the state of Guanajuato. The woman sued the husband for 50% of the properties and paid for a compensation. This came from a family violence situation that she and her child suffered. They declared the marriage dissolution. However, any of the parties were in agreement with the compensation. Before they took this matter to court, the collegiate court determined that they didn't know if a fixed asset was susceptible of being included or not in the compensation, and they determined that it was not viable to condemn this spouse to the payment of a compensation. When it reached the court, the first court considered that family violence is an illicit, a wrongful act that occurs in this particular relationship, and the patrimonial and extra-patrimonial consequences need to be repaired in a fair way and according to the entity where it happened. So this damage need to be compensated. It was considered that in this case there were harmful conducts in the emotional sphere of this woman and her child that constituted a wrongful act because this violence trespassed public order rules contained both in the national legislation as well as international treaties. The right of women for a life free of violence and discrimination, the Supreme Court has established that we need to act with due diligence to adopt comprehensive measures with gender perspective in order to comply with this duty. We have several criteria where we talk about the constitutional and conventional obligation of trying with gender perspective, the methodologies that need to be followed, helping in order to comply with the tools like the protocol to try with gender perspective and the corresponding manuals. In matters of crime, family, work that offer a thematic and specialized analysis that covers all the basic standards and criteria for the formulation of the evidence reasoning, the repairs, and the execution of verdicts. Also, we have the consideration of the superior interest of childhood when we see affectation to the rights of girls, boys, and adolescents, and we need to take this into account coming from these faculties of the judicial power of the Federation to intervene in these problems related to these kids to a degree that we can use all of these concepts and reasonings that will lead to the truth and will achieve the well-being of the minor. In this matter, we have several precedents of violence, family violence, abuse, sexual violence, and we have a protocol to try on infancy and adolescence perspective. And as we can appreciate, the jurisprudential doctrine of our highest court in these matters that involve families, gender violence, and most specifically family violence, we have abundant information. I have just mentioned some of the considerations that are most essential. It is a hard fact that family violence tends to perpetuate, to escalate into other severe forms of violence like feminicide, and challenges family as a safe and institution for development. Impunity perpetuates violence against women, so it constitutes a violation to human rights. The great possibility of placing it in a higher risk and to become a victim once again. So, from the obligation of the recognition of the rights of women to live free of violence and discrimination, one of the great challenges for the Mexican state as a whole is the access de jure and de facto of those guarantees and protections. In this respect, the rapporteurship of the rights of women of the Inter-American Commission of Human Rights in the report on the access of justice to women of violence victim women in America points that women usually do not have access to the legal resources. No resource is effective in order to make these claims, and all of these incidents are unpunished. So these rights are unprotected, and this perpetuates these violations. Likewise, it identifies that the investigation is a crucial stage when it comes to violence against women. The failures when it comes to this tend to become obstacles of the efforts to identify, process, and punish those responsible. The investigation needs to take place in an immediate manner, in a comprehensive, serious, and impartial way, and it should be oriented to explore all the investigation lines as possible that will allow the identification of the perpetrators of these crimes, so later they can be tried and sanctioned, emphasizing that the state can be responsible for not ordering or how to practice or value these tests that can be fundamental for the clarification of these facts. The Declaration on Violence Against Women, Girls, and Adolescents and Their Rights express that the states have the obligation to adequate their organic structures, processes, and procedures, to harmonize them with the Convention of Belém do Pará, to guarantee, with due diligence, to protect women, girls, adolescents against all forms of violence by gender reasons in order to prevent, investigate, and punish these acts of violence. And under this order of ideas, we can say that the minimum standards to guarantee women a life free of violence and discrimination contained in the different international treaties include having good access to legal, simple, effective remedies in order to protect their guarantees to protect their lives when they are facing violence. We need to prevent, sanction, and eradicate these violence incidents. And we need to comply with the due diligence appointed by the American Convention of Human Rights. We can say that in Mexico, we have a legal framework for protection, a broad legal framework for the jurisprudential development that addresses the standards that we have just mentioned. So we are asking, what is still missing to achieve a good and effective application of these rules that are guarding the human rights of women and for having more effectiveness in the public policies designed under these programs? Why are we still suffering this violence when we have regulations that are adequating to the international standards and we have all of these precedents? And I agree with Heide Virgin and Natalia Gerardi where they affirm that the problematic around violence against women is not the existence of the legal regulations and institutions that are executing them. It's about the effective enforcement and the effectiveness of the administrative and legal procedures, as well as a policy that sustains women in their decision to carry forward a claim in the legal system. I estimate that a legal system, as I already presented, is not just that it brings those access to challenging means, but it's more about the capacity of granting a response through a resolution that will guarantee a full effectiveness of human rights of people, especially those sectors under disadvantages, like women, girls, and adolescents that are undergoing a structural inequality that makes them victims for discrimination and violence, and everything starts in the family. And finally, in these two factors, we need to pay more focus. Family, in order to revert cultural patterns that are reproducing, trying to find the effectiveness of the legal systems, and effective access to justice to reduce impunity, to promote more trust of the citizenship, and to incentivize a greater culture of reporting. I remember a few days ago I was listening to Alejandra Spitalier. She was saying that I don't remember, I cannot think of a man that feels bad for going to work. And this violence that happens in the structure, in the family structure, when we go to work, sometimes we feel bad because we are leaving our kids behind, because we have a double responsibility. We have to go to work and we have also the family responsibility, and we want to pay attention to both of them and to be effective and committed to both of our duties. In every place around the world, violence against women, girls, and teenagers are like the worst expressions of a present phenomenon. And it's not eradicating, it's growing. And the numbers that we have observed, and in the future, 1 out of every 3 women will suffer from violence. I think this is really severe. This is a phenomenon that is causing harm to the foundations of our society. We cannot think about democracy and having a civilized society if we don't respect women. We need to promote these great changes that we need in order to eradicate it. Thank you. Thank you, Minister Esquivel Mossa. You have been quite clear in your presentation. There's no doubt that these numbers of these gender-related violence is quite alarming. It's unforgivable, and it is highly delicate. They need urgent attention in every scope. This situation of gender violence, as well as the minister just highlighted, increased during the pandemic. The thing of lockdown and all of these things triggered these numbers that multiplied, and they were just out of the ordinary patterns when it came to emergency calls and other reports. And this reflects the reality that we are living every single day in the family core. And just as the minister highlighted, family justice has many problematics in our country. One of them is saturation. In 2019, there was a study where it was mentioned that in the state of Hidalgo, for each family judge, there were like 15,000 pending trials. In Mexico City, for example, all the judges have like 4,000 unsolved trials. So this calls for a demand for local resolution, and it also highlights the importance of the matter that is being discussed here, the constitutionalization of family law. And when we bring this to a constitutional level, when these principles, these human rights are given that importance, it plays a great relevance to talk about federal constitutional justice when we refer to the superior interest of the minor, when we talk about the human rights of women. These are the fundamental rights, and in that sense, if we give them that constitutional order, if we demand them to be interpreted from that constitutional figure, we are calling for the attention of a more effective importance that is away from the local discretion. In that sense, the work of the Supreme Court of Justice of the nation covers more relevance now, starting with this judicial reform. As you know, we are migrating into a precedent system, and we need the voting of 8 ministers and 4 in the other court. So these reasons become mandatory for all the jurisdictional bodies in the country. So this judicial reform that was approved last year and that consolidates our court as a constitutional court reinforces the importance on the constitutionalization of these matters. I want to thank for the participation once again of the minister, and now I will proceed to welcome and to introduce Reem Alsalem, who was appointed United Nations Special Rapporteur on Violence Against Women, its causes and consequences in July 2021 by the UN Human Rights Council for a 3-year tenure. She has a master's degree by the American University of Cairo, Egypt in 2001, and a master's in human rights law from the University of Oxford, United Kingdom of Great Britain and Northern Ireland from 2003. She is an independent consultant on gender issues, the rights of refugees and migrants, transitional justice, and humanitarian response. She has consulted extensively for United Nations departments, agencies, and programs such as other non-governmental organizations and the academia. She previously worked as an international civil servant, serving in the UNHCR in 13 different countries. During her service, she has planned, implemented, and monitored programs that serve to protect persons that were survivors of gender-based violence, particularly women and girls. Thank you. Thank you, everyone.
Esteemed Mrs. Alejandra Spitalier Peña,
Esquivel,
esteemed judges and members of the Center of Constitutional Studies and also of the Supreme Court, Professor Choudhry, ladies and gentlemen.
Damas y caballeros,
it gives me great honor to be here with you today, to be in the company of such distinguished panelists and distinguished audience. As we've heard, Mexico and the region actually as a whole has made enormous strides when it comes to the prevention and response to violence against women and girls. And therefore, when I received the invitation to come to Mexico to share the international aspects of the work that I do, but also to get to know better the experience and the good practice and the efforts that Mexico is making in order to prevent and respond to violence, I could obviously not say no. It was a great opportunity. I know that Mexico also has a lot of experience with special procedures. But since there are also others that are not in this room that are following this conversation, I'll just maybe say a few words about my mandate, which is one of the oldest special procedures in the Human Rights Council of the United Nations. It's actually been around for 30 years. It was created by the then Human Rights Commission. And actually, the mandate holder, which is myself, we are independent experts, so we are taken on board because of our expertise, but we are not really regular staff of the UN. Our accountability really lies to the Human Rights Council, and it lies to the victims that we represent. Now, as you know, this mandate is global. It has a very ambitious agenda, which is to really work with all stakeholders, whether it's states, whether it's regional organizations, whether it's civil society, victim organizations, victims themselves, on the issue of violence against women. And although the title that I hold does not specifically include girls, however, since well, there is a continuum of violence that starts very early on, the mandate does work on girls as well. We do work on specific issues, like, for example, female genital mutilation, early unforced marriages, and so on. And I would like to work more on girls, but given the small size of the mandate, one has to prioritize, but it's certainly something that I would like to do more of. So today I would like to maybe touch on 4 issues, actually 5 issues, that the mandate has worked on when it comes to domestic violence issues. So these issues are, and if we can show the first slide, please. Is rape and domestic violence, the intersection between COVID-19 and domestic violence, intimate partner femicide, gender-sensitive and child-centered custody processes, and then gendered stereotyping and patriarchal attitudes in the administration of justice, which also Justice Esquivel touched upon quite extensively in her remarks. So when we look at rape and domestic violence, in the report to the General Assembly that the mandate delivered in 2020, the mandate stated that the criminalization of rape should also include rape between spouses or intimate partners. So it called on all states that exclude the criminalization of marital rape to rectify that situation, since it's in contravention to international human rights standards and must be repealed. Now, of course, I fully understand and welcome that Mexico has criminalized marital rape and also intimate partner rape. So this is wonderful. And the criminalization of rape should explicitly include all types of penetration, however slight, of a sexual nature with any bodily part or object. The mandate has also recommended that the lack of consent should be really at the heart and at the center of any definition of rape, including rape by an intimate partner or spouse. So in this sense, when you put the issue of consent or the lack of consent at the center of defining rape, the issue of use of force or the threat of use of force can provide evidence, perhaps, that there may or may not have been consent, but it's not a constitutive element of rape. The mandate has further recommended that the following situations should be included among the aggravating circumstances for the crime of rape. One is when the perpetrator is a former spouse or intimate partner or a family member, if the victim was or was made vulnerable through the act, obviously if the victim was a child, and if the act was committed in the presence of a child, and the fact that the act results in physical and or psychological harm for the victim or both, and also if the act was committed by 2 or more people, and if the act was committed repeatedly, including through the threat or use of force. The mandate also called on states to abolish all mitigating circumstances that are not in accordance with human rights standards that exist in a number of places. For example, as you may know, in some countries there are legislations that oblige the victim to marry the rapist. So these things should be abolished. The mandate also did quite a bit of work on the intersection between COVID-19 and domestic violence. And in fact, in 2020, it presented a report to the UN General Assembly on this intersection. And in the report, the previous Special Rapporteur had noted that the majority of extraordinary measures adopted by governments around the world in response to the pandemic, and particularly in the first year, were largely gender blind. Meaning that the lockdown measures, combined with restrictions of freedom of movement, had actually increased or contributed to the increase of gender-based violence against women, especially domestic violence. As you can imagine, due to these measures, women, girls, but also men were finding themselves locked in the same space with their aggressors or with the rapers or with their, the person perpetrating the violence. We also saw that there were fewer police interventions. In some places, courts closed. There was more limited access to helplines. There were more limited access to protection measures and to sexual and reproductive health services, as well as also closure of shelters and safe accommodation for victims. All this has aggravated the risks faced by women and also decreased the available services and protection mechanisms for them. And since data on violence against women was already very challenging before COVID, and we heard it is really a pandemic of violence that we're seeing in the world, the COVID situation actually exacerbated or made worse this challenge that we have when it comes to lack of comparable data when it comes to violence against women, particularly, I would say, in the area of femicide. So moving to the area of femicide, and here I'd like to focus on intimate partner femicide since we are talking about domestic violence. As you very well know, studies continue to show that women are the primary victims of intimate partner killings, and that the prevalence of a prior history of violence is often present in the lead-up to the femicide itself. Therefore, by improving the response to cases of domestic or gender-based violence, the incidence of femicide can be reduced. Ensuring improved data collection and use in the development of prevention and response measures is also important. And actually, this morning I was in another sort of event on femicide, and one of the speakers rightly noted, if the data that we collect does not influence policies, does not improve the understanding of the reasons and situation in which femicide happens and the needs of women at risk and the needs of victims and their families, then why are we collecting data, right? And based on general recommendation number 35 of the Convention on the Elimination of All Forms of Discrimination Against Women, the mandate has actually also highlighted the importance of collecting data on the number of complaints filed on gender-based violence, including femicide, and also stressed that there was a need to disaggregate data by type of violence, also to speak about or include the relationship between the victim and the survivor and the perpetrator, as well as in relation to intersecting forms of discrimination against women and other relevant socio-democratic characteristics, including the age of the victim, for example. And this analysis, as we said, should enable the identification of protection failures and serve to improve and further develop preventive measures. And in fact, because of this very big challenge that exists worldwide when it comes to data, my mandate has also set up a Femicide Watch initiative through which we have called on governments around the world to also set up their own femicide observatories or femicide watch, and to collect through these femicide watches comparable data at the national, regional, and global level. Now, though challenges remain, I would like to say that from the 4 or 5 years that the mandate has been monitoring the issue of femicide and also the collection of data and the setting up of observatories by states, one can say that significant progress has been made in the last 5 years towards the creation of different types of bodies with the purpose of monitoring violence against women and femicide. There has been also progress when it comes to collection and systematization of data on femicide, although different countries still use different methodologies. And a lot of these advances actually have also been made in the Latin American region. And through the information we received from countries and also from national human rights bodies last year, we have seen that femicide continues to be largely monitored within the framework of domestic violence or family violence. Similarly, where states have adopted national plans to address femicide, they have done so largely through a heavy focus on ending domestic violence and intimate partner violence. So we've seen that kind of approach in Albania, Azerbaijan, Iraq, Malaysia, Norway, Serbia, and the Ukraine. And if you look at these countries, and this I think is an interesting point, countries are struggling with basically monitoring femicide, collecting data, and also tackling this irrespective of where they are, whether they are global north or global south, in the global south, whether they are in times of peace or in times of conflict. So basically, you know, what you hear that it depends very much on resources is not actually true, because you have really a wide array of countries that are struggling with this issue. Now, on this issue, the mandate has emphasized on numerous occasions that while the category of domestic violence, family violence, and intimate partner violence are all relevant categories for understanding the phenomenon of femicide, none of these that I've just mentioned are sufficient as standalone proxies for femicide. And we are still concerned from the perspective of the mandate that a number of countries have still yet to introduce criminal legislation on the specific offense of femicide. So in a number of countries, femicide is still not criminalized. Now, moving to a third area on which the mandate has worked when it comes to domestic violence, there's the whole area of gender-sensitive and child-centered custody processes. And there the mandate has expressed actually its concern on numerous occasions about the cases of women who have lost the custody of their children to abusive fathers. And since I arrived in August 2021, actually I've worked intensively on a case in Spain where actually there are many more cases, but also in other parts of the world, including in Latin America. And basically, what the situation is that courts in several countries have been using the concept of parental alienation, or in some cases the parental alienation syndrome, pseudo-theory when assessing child custody cases, particularly when a child expresses fear of avoidance of a parent. And despite lack of scientific support and the fact that the World Health Organization excluded the parental alienation syndrome from the classification index, it continues to be used explicitly or implicitly as a reference in the justice system worldwide, with serious implications for human rights of women and their children. Now, what is worrisome in the way the parental alienation syndrome is used is that there is ingrained gender stereotyping, which has led courts around the world to favor the testimony of the father at the expense of the mother, even if the mother brings forward well-founded allegations against the father, stating that he's been abusive of the child and that he was also perhaps subjecting the mother to intimate partner violence. So in other words, and despite clear guidance to the contrary in the Convention on the Right of the Child, these courts in those countries continue to determine that it was always in the child's best interest to maintain contact with the father, granting joint custody or sole custody even when the father was abusive. So here the mandate and other regional human rights mechanisms have repeated the calls that the determination of custody and visitation rights, violence against women should be taken into account in all custody cases, and that the perpetrator's rights or claims during and after judicial processes, including with respect to property, privacy, child custody, access, contact, and visitation rights, should be determined on the basis of human rights of women and children to life and physical, sexual, and psychological integrity, and be guided by the principle of the best interest of the child. Finally, I'd like to move to the issue of gender stereotyping and patriarchal attitudes in the administrative of justice. And despite the short time that I've spent as a rapporteur, it's very clear to me that gender stereotyping and patriarchal attitudes do negatively affect judicial processes, also when it comes to family law and also custody processes, and that the degree of this influence is often underestimated, in fact. Now, many judges ascribe to individual women or girls specific attributes, characteristics, or roles by reason only of the woman's membership of a particular social group. So then they perpetuate these harmful stereotypes through their failure to challenge the use of these stereotypes. And of course, the problem here is that because they exercise a lot of power by virtue of their position as judges, they can give stereotypes the full weight and authority of the law. And I think the Abril Rosales versus Argentina case is a good example of how such attitudes not only result in ignoring the signs that women and their children are subjected to violence by intimate partners, but also how they result in the continuation and intensification of violation of human rights in the form of re-victimization, discrimination, and victim blaming. And when this happens, it doesn't only affect women or their family members, but it can actually weaken the overall delivery of justice, including for males, including for groups of males. And states have an obligation to ensure that gender stereotyping is addressed and dealt with adequately. And there are various articles in the CEDAW Convention that ask states to take all appropriate measures, including legislation to abolish existing laws, regulations, customs, and practices which constitute discrimination against women. It also asks states to take measures to modify the social and cultural patterns of conduct of men and women, which is the issue that also the Justice spoke to, with a view to achieving the elimination of prejudices and customary and all other practices based on the inferiority or superiority of their sex or gender. Now, of course, there are many other international treaties and agreements and customary law that include this inherent obligation of states to treat everybody equally and without discrimination. For example, everyone has also a right to a fair trial, as you know, and equality before the courts. And this obligations that states have applies, of course, to all branches of the government, including the judicial branch. So gender stereotyping in judicial processes can lead judges to have preconceived ideas about the credibility of the witness or whether a violent offense has taken place in the first place. And to counteract that, we need to highlight the harms that this kind of stereotyping causes through evidence-based research. We need to continue to advocate for legal and policy reforms that prohibit it. We need to monitor and analyze judicial reasons for evidence of stereotypes, and we have to highlight examples where these practices of stereotypes are challenged and improve the judicial capacity to address these stereotypes. There's also no doubt in my mind that having more women judges and prosecutors in all their diversity would lead to improving this incorporation of a gender lens in the work of the judiciary. And here the Special Rapporteur on the independence of judges and lawyers mentioned in his 2021 report just how difficult it is for women to advance in a judicial career, in part because of how pervasive gender stereotyping is. In fact, to borrow his words, he described this as a plague, and I cannot agree more. A gender-centered perspective will also need to be deliberately applied as a criteria for studying and resolving cases. So to conclude, my mandate has highlighted that the fact that even the best legislative reforms will not produce the desired effect if there is no political will to implement them, and if no attention is paid to investing resources and to also making a political commitment to deal with this issue, and also to address the issue of impunity, as the Justice mentioned, which continues to be rampant for these crimes. And I will stop here, given the shortage of time. Thank you very much for your attention.
Thank you very much, Reem, Alsalem.
It is really important, and we feel honored to have you here in Mexico as Special Rapporteur of the UN. When it comes to these topics, it has been a privilege to listen to you and to highlight this important data. And it has been a really vast presentation, and I can highlight that this rapporteurship is one of the oldest, as you mentioned, and it is a rapporteurship that has a great demand given the complexity of these problematics and all the different factors involved in these issues. You have made clear how we can improve this response to family violence and how it has a direct impact on the reduction of crimes like feminicide. Unfortunately, in Mexico, we have alarming numbers when it comes to it. Last year, we exceeded the record of feminicides in the country, and this year we have already exceeded the number of 2021. That's the size of the issue here. Also, as Reem mentioned, these data oftentimes are just like numbers, and we get used to these numbers. But behind these numbers, there are stories, there are faces, there are women. And as the Special Rapporteur says, if we don't make public policies, and if we don't have the political will that is clear enough, that is moving towards those numbers, these numbers make no sense. It is useless to collect all of this information and to tell them to everyone if we are not doing anything. And I go back to the data that we shared in the beginning. These numbers are alarming, as I said before. One of the feminist fights on an international level that are most important, well, is to bring forward this topic of family violence, because the state should not only look at it, but also they need to intervene, because sometimes it's not within the scope of the family. This is about law, and this is about the participation of all the stakeholders, and the state is one of them. And there's no doubt, as Reem said in the conclusion of her presentation, the most important affectation that we can have on all levels when it comes to gender is the stereotypes. These patriarchal systems that are not allowing to have equal conditions for women's rights to be safeguarded and to have this protection that will actually bring equality to eliminate these phenomena. Because violence is a phenomenon that can reflect all of these problems that we have when giving women their right and their place within the family, for instance. So in that sense, I want to highlight the commitment by the federal judicial power, where in this administration, Arturo Saldívar has had in his agenda one of the cross-cutting axes of his policies has permeated in all the different levels. Also, as Reem said, it is important and it transcends directly. Having women in the justice system, judges, magistrates, ministers, making resolutions in these cases, so this perspective can actually transcend in the application of justice. And in that sense, we have had different contests where we have more women participating in better positions and in better places. So this is one of the commitments that we have. Thank you once again, Reem. And now I have the pleasure to present Professor Yasmín Choudhry. She is a professor of law of the Oxford University and fellow of the same university. She is also a member of the Inner Temple. In her work, we can highlight the European Human Rights and Family Law, her monograph in 2010. Also in 2009, a collection with Routledge Cavendish on gender and family law, and also the Cambridge Companion to Comparative Family Law of Cambridge University Press in 2019, a collection that explores the key questions and themes that have faced family law in different key jurisdictions. Among other functions and roles in gender violence, Professor Choudhry has worked in the Joint Parliamentary Committee on Human Rights Inquiry into Violence Against Women in 2014 and 15, and as a special advisor to the Joint Committee on the Draft Domestic Abuse Bill in 2019 in England. On a European level, she has been an expert for the Council of Europe, among other functions. Welcome.
Thank you very much for the introduction, and thank you very much to all of you for attending today, particularly Justice Esquivel for your support, which is very much appreciated. And I'd also like to thank the translators, who will have probably a very hard job with me today. And also can I just thank the court for this invitation. I'm absolutely delighted to be here, and I think it's probably to be here at one of the most innovative constitutional courts, I think, in the world. And also, I think, world leading in terms of having a dedicated research centre in the Centre for Constitutional Studies. I don't think we have that in the UK, and I wish we did. And I'm also delighted to confirm that we will be shortly concluding a memorandum of understanding between the Centre for Constitutional Studies here at the Supreme Court and the University of Oxford. And I hope that we will continue to do that work, and we're going to hopefully do a programme of research on violence against women and girls. So I'd really like to commend the Supreme Court for its support of the Centre and the work, the very, very important work that it does. So what I'm going to talk about today, really building upon the speeches that we've already heard, is domestic abuse and the family court system, and focusing particularly on the European experience and the impact of the Istanbul Convention, which is the European Convention on Violence Against Women and Girls. So let's just start with, first of all, the issue, which I think we've already heard about today. But in terms of Europe, and in fact, in terms of the world, domestic abuse is one of the most serious and pervasive forms of violence against women, and constitutes, as we all know, a violation of their human rights. And the most comprehensive research that was conducted by the EU Agency for Fundamental Rights found that 1 in 3 women in Europe have reported some form of physical or sexual abuse since the age of 15, and that most violence is carried out by a current or former partner. So given the prevalence of domestic abuse in relationships, it's not surprising to see that it comes up often in the family courts. And a focus of increasing concern has been the effect of domestic abuse on children and the dangers imposed by post-separation contact. There's a vast body of research now which points to the negative effects that domestic abuse can have on children, as well as the potential overlap between domestic abuse and the direct abuse of children. Separation from the abuser can often, we know, be the most dangerous period for victims of domestic abuse, and that includes adults and children. It's at this point they're at the most risk of death and violence, and that is because they have removed themselves from the coercive control situation of the perpetrator. And it is this that is the most important matter in terms of the family courts. The issue being keeping women and children safe, because they are the element of the population which has the most disproportionate impact in terms of domestic abuse. A recent study in this field concluded that adult and child homicides that occur in the context of domestic violence have warning signs, which I think Reem talked about as well. Often when we hear about homicides, there's a history and pattern of domestic abuse. So the issue very much is, how do we keep victims of domestic abuse safe within the family court system? This is an area of research that I've been concentrating on in the last few years. So slide 2, please. So as I said, it's imperative that legal systems ensure that the safest decision is made. Unfortunately, there is increasing evidence across Europe that these obligations are not being met. And this is largely due, despite the differences in the legal systems and family court processes, to a number of common failures by domestic, civil and family law systems. And those are a failure really to understand the risks associated with post-separation contact, where domestic abuse is a feature. It's now abundantly clear from the research to date that there is a clear and persistent pattern of abuse and of domestic abuse being minimised by family courts and professionals dealing with post-separation arrangements for children, leading to the exposure of victims and their children to unsafe and potentially life-endangering contact arrangements. And this in turn is due to a culture where the concept of the best interests of the child has been interpreted to mean a strong presumption towards contact with both parents, and a perception that contact should always be awarded to the non-resident parent. Now, this cultural shift is without doubt due in some part to the success of the fathers' rights movement in Europe and internationally, which claims that fathers are disadvantaged by a family law system that favours mothers in these disputes. And therefore, in not awarding fathers sufficient contact or failing to enforce contact orders, courts are failing to operate in the best interests of the child. What's particularly striking for me in my research has been the employment of human rights narratives by the fathers' rights movements and by domestic abuse perpetrators, and also an apparent gender bias against mothers when attempting to argue for the same rights for protection for themselves and their children within court proceedings. We don't see a corresponding mothers' rights movements, I don't think, in any country in the world, and I think that's something that we should note. Furthermore, women's organisations across Europe and the world have noticed that there's an evidence generally of a culture of disbelief towards victims, and that is why we have a minimisation of domestic abuse within family court processes and an increasing use of this concept of parental alienation, which Reem has already talked about today. As we know, it has absolutely no basis at all in terms of the scientific community and in terms of the academic merit, and these issues were also noted by the UN and its Beijing regional review meeting in 2019. So it's of concern that parental alienation has this level of effect in these proceedings. Now, in terms of slide 3, which can we move to that? Thank you. The European Court of Human Rights has undoubtedly played a pivotal and crucial role in not only in terms of recognising domestic abuse as being within the scope of a number of rights within the European Convention on Human Rights, but also in the development of a range of positive obligations that member states must comply with in this regard. And the court has firmly established that domestic abuse falls within the scope of Article 2, the right to life, Article 3, the right to freedom from inhuman and degrading treatment, and Article 8, the right to private and family life, and also Article 13, the right to an effective remedy. And in its landmark judgment in Opus and Turkey, it held for the first time in a domestic violence case that there had been a violation of the Convention of Article 14 in conjunction with Articles 2 and 3, i.e. discrimination. Making the observation that domestic violence affected mainly women, the court held, and this is a very important point in terms of the court's role, that the general and discriminatory judicial passivity in Turkey created a climate that was conducive to it, and the violence suffered by the applicant and her mother could therefore be regarded as having been gender-based and discriminatory against women. So the climate within the courts themselves is capable of giving rise to discriminatory treatment under Article 14. And I think that's a very, very important point for us to note today. Now, the court has also developed a number of principles within the context of domestic abuse, which I have set out on the slide there. First of all, as part of its positive obligations under the Convention, the state has a responsibility to ensure that the ECHR rights of the victims of domestic abuse are protected within both criminal and civil proceedings. This includes the need for state authorities to undertake effective investigations and risk assessments. A failure on the part of the state, therefore, to do so may constitute a breach of Article 3 and Article 2. Second, with respect to the absolute rights, such as Article 2 and 3, there are no circumstances in which it is permissible for the state to infringe their rights. In other words, the state cannot justify its failure to protect a survivor and her child's Article 2 or 3 rights in an access or custody case by referring to the perpetrator's rights to respect for family life, which, as we know, is a qualified right. But this is often the case in family proceedings. Third, due to the fact that domestic abuse disproportionately affects women, a state's failure, even if unintentional, to protect women against domestic violence will breach women's rights to equal protection of the law under Article 14. And as I said earlier, the particularly important point there is the role that judicial passivity can play in establishing that discrimination under Article 14. If we move to the next slide, please. Oh, you're already there. Okay. These issues are foreseen and addressed in the Istanbul Convention, and there are a number of articles which are relevant. As you can see there, Article 26 recognises that exposure to physical, sexual or psychological violence and abuse between parents or other family members has a severe impact on children. Article 26 sets out the obligation to ensure that when providing services and assistance to victims with children who have witnessed violence, their rights and needs are taken into account. And the term child witnesses here refers not only to children who are present during the violence and actively witness it, but also those who are exposed to screams and other sounds of violence while hiding close by, or who are exposed to the long-term consequences of such violence. Often we see judges making comments in cases all over the world about how children cannot be victims of domestic abuse because they never actually physically witnessed it. What we do know from research is that children are very much aware that domestic abuse is occurring in the household. And finally, the last article there is Article 45, which requires parties to improve sanctions which are effective, proportionate, and dissuasive. And that's really referring to ensuring that the right types of orders are being made. And that can also include, therefore, not awarding contact or access to the child, not awarding custody, or indeed awarding supervised access only to the child, or indeed what we call indirect contact, which is letters and telephone calls, because it simply may not be safe for that type of contact, any other type of contact to occur. And so what we're really requiring, the Istanbul Convention is requiring, I think, in these cases, is for judges to actively engage in risk assessments when these cases are present. When domestic abuse allegations are made, a risk assessment process has to take place at that point, because it really is a matter of life and death for a lot of survivors of domestic abuse. Now, of course, in order to do that, they have to have the right information in front of them. They have to rely clearly on good assessments from the professionals involved in the process. But that is what is required, effective risk assessment and management. If we move to the next slide. Here, I'm going to talk about Grevio, which is the monitoring body under the Istanbul Convention, which has now produced a substantial set of reports as they have completed quite a number of state monitoring visits. And this issue in terms of domestic abuse in the family court systems has been coming up in every single report that they have produced. As you can see there, they have noted a number of challenges and identified a number of challenges in a range of evaluation reports that they have prepared, and I've just listed them there for you. First of all, they've noticed that there's just generally insufficient measures to ensure the safety of victims of domestic violence and their children. And that's referring to the lack of risk assessment procedures that are occurring, allowing contact, unsupervised contact, not really thinking about the safety of the victims in allowing this contact, or indeed, in fact, giving custody in cases where there's clear evidence that it's not safe for either the child or the adult victim. Secondly, they've noticed that there's a general lack of provision of protection and support to child witnesses when violence occurs in the family unit. And this is very much directed towards the state rather than the court. The state is required actively to provide a positive range of measures for support for domestic abuse victims, and allowing them to have that. Thirdly, they've noted the increasing use of parental alienation as a means of minimising evidence of domestic abuse in civil proceedings. Now, despite what we know about parental alienation being incredibly unscientific, we see that it's actually successfully used in a number of courts and jurisdictions, and that is obviously problematic because it's being used by perpetrators to minimise not often just the domestic abuse, but also to undermine evidence where there is that the child does not wish to have contact because the child does not feel safe. And it's a very effective ploy, therefore, to argue that the child is parentally alienated from the father. And unfortunately, that is being used quite successfully. Fourthly, they talk about the lack of attention being paid to the wishes and feelings of child victims of domestic abuse. Now, of course, this varies across jurisdictions. In the UK, for example, a child over the age of 10, their wishes and feelings should generally be followed. And I think that's a relative principle that I think most jurisdictions employ. But we see that time and time again, older children who are making it very clear that they do not wish to see the father perpetrator of domestic abuse, and because they actually feel unsafe, their wishes are being ignored. And we also see where there's evidence with younger children who are clearly displaying signs of fear of seeing the father, those signs are being ignored by courts. And that is obviously very concerning too. Fifthly, they've noted an evidence of bias and a lack of training among professionals. I've engaged in quite a lot of qualitative research in relation to the experiences of survivors. In fact, I'm currently doing a project at the moment, a comparative analysis of 7 countries. And what we see often from survivors is when they talk about the fact that they have there's a double standards approach being applied to them at all times. When they talk about their experiences of domestic abuse and they express emotion, they're regarded as being potentially defective in terms of parenting. When they come across as not emotional and very clear, then that's used against them to say that, well, it really hasn't had a very negative effect on you, has it? Whereas when men are emotional in court, the fathers, that's regarded as somehow evidence of their parental care and love. So you can see that there's double standards being applied in relation to women in particular, who are, as we know, predominantly victims of domestic abuse. So this is very much about gender stereotyping, which I think all our speakers have talked about today, and the importance of removing bias where possible and ensuring that training takes place amongst professionals. Another issue that comes up quite a lot in relation to experiences of the judiciary and also in terms of lawyers is just a general lack of understanding about the dynamics of domestic abuse and how those dynamics can actually play out in the courtroom. What we do know about perpetrators is they're very good at hiding their domestic abuse, and they often come across as very charming. And that's exactly what happens in the courtroom. So you often have a very charming, articulate perpetrator, and you have a very emotional and very clearly rattled victim of domestic abuse who is finding it all very, very hard. And what do judges do? At the end of the day, you have to decide whose evidence you prefer. And this is where the bias comes in and can be really, really destructive in such cases. And finally, they've noted in some jurisdictions that child victims are actually penalised for their experiences of violence, in the sense that if they talk about their experiences, what can often happen is that some jurisdictions will commence child protection proceedings and remove the child from the mother because they're seen as a victim of domestic abuse. And that's clearly not a good thing either. So what's the answer? Well, the answer, or what is needed, A number of issues. So next, final slide, please. Thank you. Grevio has set out what's really required. I'm just reading from my rather small version here on my phone. So as you can see, the first thing they talk about is the need for adequate screening, and that's really about risk assessment and making sure that these cases are screened right at the beginning of family proceedings, so we're aware that it's a domestic abuse case, and so we know what we have to do in terms of process. Strengthen institutional cooperation. What we often see time and time again is that the criminal court is doing one thing and the family court is doing another, and they're not talking to each other. So you'll find, and in fact there's been an analysis of this, it's been called the three-planet analysis of what happens. We have the criminal planet, the criminal law planet, which is saying to the survivor, right, clearly you must not allow any contact between the child and the father because there are criminal proceedings. There is a bail condition attached, possibly, not allowed to see child. You've got the child protection planet saying similar things. You're not allowed to have contact with the perpetrator because this is a child protection issue and we will remove the children if you allow contact. And then you have the family court planet, which is saying, guess what? You must allow contact between the father and the child because it's in the child's best interests. And these planets are just operating without really talking to each other. And that's one of the major problems that we have. As I said earlier, there needs to be appropriate training. There needs to be a recognition that mediation absolutely should not be used in cases where domestic abuse is being alleged. And that's because of the power imbalance that is clearly present in a relationship where domestic abuse has occurred. You cannot negotiate with somebody who has been your abuser. And it's as simple as that. But time and time again, we see that these cases are referred for mediation and alternative dispute resolution. Wider levels of awareness amongst professionals about the dynamics of domestic abuse, as I talked about earlier, taking the wishes and feelings of children into account, ensuring that the necessary resources are there to provide safe contact. So, for example, if it's not safe to allow contact, consider whether you should be ordering contact, but also consider resources such as contact supervised centres, where the victim does not have to have contact with the perpetrator. Ensure a dedicated specialist support services are available, and finally ensure that the relevant professionals are aware of the absence of any scientific basis for the theory of parental alienation. And with all those steps, we should have a better system. And I'm going to leave it there. Thank you very much for your attention.
Thank you very much, Sasha. Muy interesante todo el...
All of this work, all of this academic work that has been shared by Professor Choudhry is quite interesting when it comes to all of these domestic violence phenomena and how you highlight the obligation of the state to maintain the safety of these victims. The state cannot justify not giving enough tools to protect them inside this first circle, which is family. And within these invalid pretexts, the judicial power needs to be careful with this phenomenon of parental alienation that has been related to many cases of family abuse where the minors are aligned to one of the parents. And sometimes these statements in the trials come from this relationship that they have to one of their parents, and this is sometimes not well addressed. So they can re-victimize women, but also children. And you also highlight how within this context of family violence, besides harming women, because this is also about gender, it has a direct impact on girls, boys, minors in general, also adolescents. And it is not valid either to say that if there's no physical violence, then the minor won't be affected by this. This is a sensitive phenomena that transcends boys and girls, and it is not valid to use all of these pretexts. And I want to highlight the importance of having all of these different gender perspectives and these protocols that as judges need and must be used when solving a case where all of these rights are involved. These protocols suggest ways to apply the law, to enforce it through studies, through a comprehensive vision of these phenomena in all the different axes. Finally, I want to highlight this phenomenon that Professor Choudhry mentioned. It makes it really hard to solve these cases because there are different planets, as you mentioned, that regulate all the different rights involved. We have the legislation ordering that you cannot allow the aggressor to be in contact with a minor or with a woman that is being affected by this violence. And also there are regulations that say that we need to focus on the well-being of the minors, so they need to be in contact with their parents. So this leads to understand how complex this issue is, and that's where the judges need to be careful and they need to understand all the different aspects of each case. Once again, I want to thank our three panelists. I think this has been a quite fruitful discussion. We see the importance on the issue and the different perspectives of the issue, and this makes us be committed to take some action and not reducing or losing sensitivity towards these problems. And I would like to close with a quote that is quite moving, and I found it during the preparation of this discussion. It's a quote from Louise Lee Cinder, and she says, "If we read any news on domestic violence, invariably we question the victim. Why didn't she leave him? Usually we never ask ourselves, why was he violent? We should not ask ourselves why victims remain in these relationships. It would be better to ask, how can we protect these people? Without losing time asking why she stayed or why she let him do it. We should only ask ourselves one thing: how can we protect her?" I want to thank you once again, all of our panelists. Congratulations. Congratulations for the organization as well, for the center. Thank you, and see you later.